Good morning, Trinidad and Tobago. A special good morning to the members of the media who have joined us for opposition press briefing this morning. I am joined by my colleague MP Dinesh Ramboli. I am Anita Haynes, the Member of Parliament for Tabaquite and Opposition Shadow for Education. Today we are going to be discussing two very critical issues for government accountability. What we are seeing right now is that the government of the Republic of Trinidad and Tobago, led by Dr. Keith Rowley, that they want the power that they have, but they want zero accountability. And so I will be leading off this morning's press conference with a critical look at our education sector. And as I promised on the last occasion that I was here, we would be doing an evaluation of the vacation program, the remedial program for students who scored under 50% at the SEA exam. We, as a responsible opposition, we take very critical looks at what is happening in this country. We listen to what the government has to say. We allow the rollout of their programs, and then we do an assessment and evaluation. This manner of monitoring and evaluation is clearly absent in the government, and we are faced right now as a nation looking as the next generation of Trinidadians and Tobagonians grapple with incompetence at our policy making level. And so I'm going to go through some of the things that we have raised prior to the start of this program and a critical assessment of what is happening at this present moment. And we're doing so now in the hopes that the government can take corrective action, because I want to start with the fact that we are not opposed at all to students getting access to remedial work or getting access to a program that will allow them to get up to scratch to start the secondary school term in September. We are, however, very opposed to any attempt to put a pretty face on a glaring problem. And so if this program is designed with faults, if it is designed and it is not going to work, we see it as a very responsible opposition, as policymakers in waiting, to strike the issue now and ensure that the ministry has the opportunity to address the concerns of key stakeholders, to make the necessary changes, and to ensure that this program does what it is intended to do. And so we had in the past week news that of the 9,000 students that this program is targeted towards, only 2,700 thereabouts have signed up for the program. The ministry has said that there will be in-person signing up at the schools, etc. But what we have is no answers to the question as to what happens if you do not attend. Are you still going into the secondary school system, having not attended the classes, knowing that you have not made the grade to show the competence necessary for the secondary school exam? Have they considered how you are reaching out to those parents? Because you know the students who have not gotten the grades. How are you ensuring? Now, this is not to say that there is no parental responsibility, but there is a space for policymakers in this, and therefore that is what we're discussing. We are looking at the fact that if only 2,700 students have signed up at the beginning, this leaves no room for who falls out of the system over the vacation time period. And so what we're looking at is the question of, is the program going to meet its necessary aims? And so, having spoken to teachers, parents, and key stakeholders, I'm here to raise some very serious concerns. In the first instance, the vacation program is meant to do remedial work. It is meant to target students, as I said before, who have not made the necessary competencies or demonstrated the necessary competencies to attend secondary school in September. However, at these 33 centers, while I applaud the teachers who have so graciously volunteered their time and their efforts to accommodate these classes or facilitate these classes, The fact is, they are going to be going into spaces with students that they don't know. They have no experience with these students. They don't know what their capabilities are. They don't know what they're missing. They don't know where they may need the extra help. And so that being said, was there any space, therefore, for students going into the program that their standard 5 teachers or the previous teachers could send some report so that you will know, okay, is it the problem is with reading comprehension, is the problem with math, is it specific sections, etc. Because again, this is meant to get these students into an equal playing field, an equitable playing field actually. And so to just go over a general curriculum and check boxes arbitrarily, I do not believe, and many key stakeholders do not believe, that we're going to see the desired results. You also have the fact that going into this, again, with a generalized teaching plan, there was at no point did the ministry say, okay, we'll take the 2-week period or the 3-week period, and the teachers who have volunteered their time would be given any extra training in doing remedial classes. That would have been a step in the right direction. It would have showed that the ministry is thinking about what the program is intended to do, as opposed to just saying this is what we're doing. I want to be very clear. The entire nation, teachers, the Prime Minister himself said it, that no one was surprised by the results. No one was surprised by the results. That being said, the PNM administration failed on every occasion that they had to put key interventions in place to mitigate against what we saw 2 weeks ago. Therefore, this new intervention, with the absence of key targets and deliverables, will leave us in a worse problem come September, because people are going to feel as if the problem was solved and there was no solution, no actual solution. Are these students going to get a consistent, concerted effort to continue their development? Are we going to see a consistent and concerted effort? Or is it at the end of 1 month we say, okay, go ahead and go back to the status quo, go back to same old? As I was speaking to some teachers, and they told me that in the past, when we had the junior secondary school system, that there was a facility that allowed for remedial classes in the afternoon, because in the junior secondary school system, for those who may not know, there was half-day school, and so there was a time to facilitate any remedial classes. Have they been looking into what we are going to do post the 1 month period? This gets me to the other point. How are we evaluating the program? Is it at the end of 1 month there will be a test? Is it at the end of every week we are measuring the progress of the students? Or is it that we just say once we've completed 1 month of vacation classes that we've done something and the students are now ready? Are there going to be any specific testing and measures in the first term of secondary school to see how students are coping? These are very, very critical concerns, unanswered questions, as it were, because if you aren't testing, if you aren't sure that the system is working, then what are we really doing? And whether or not your child is in this 9,000 or it's that somebody you know, this is an issue for the nation. Because if we have thousands of students falling through the gaps in the system, you have extrapolate this 5, 10, 15 years down the line, we already have an unemployment problem and an underemployment problem. If you have students who aren't even able to go through the compulsory elements of school in the school system, and they are, by the numbers that we have, now this is just the numbers that we have, I want to remind everyone, during the pandemic, at a joint select committee meeting headed by Senator Paul Richards, the information, the data coming to the public is that some 47,000 students never accessed online classes. We have no way to put this 9,000 into that 47,000. We don't know where they fell. We don't know if they were accessing but dropped off, and we have no numbers for whether or not these students from this 47,000 students even sat the exam. And that's why I say we exist in a data deficit. We exist in a ministry that always comes to the public to placate us and tell us it's not so bad. It's not so bad. You know, we're doing our best. It's not so bad. And then the results come out and it really is worse than we thought. And so we are looking at a data deficit. We are uncertain of the exact numbers of students who have been left out of the system. This 9,000 may just be a drop in the bucket. May very well just be a drop in the bucket. I want to raise some key concerns about how you can ensure greater participation in the vacation classes. School transportation has been an issue that I have been raising throughout the system. I acknowledge that the ministry had said that they are going to go into communities and you would go to the class closest to where you live. As a representative for a constituency with a significant rural component, I can tell you it does not work the same for everyone. Let's put it in context of parents. What happens in the vacation period? This school term that we are set to start in September is set to be the most expensive school term. I am talking about rising cost of living from food, uniform, books, etc. It is going to be very expensive for parents. Now you have to ask these same parents to facilitate getting their children to and from the classes. Now in urban communities, you may very well be walking distance. It may be one taxi. In communities like the ones that I represent, you're talking about 2 and 3 taxis in some instances. And so the students who were disadvantaged in the first place with connectivity issues because they weren't able to get Wi-Fi access, etc., are the students who are equally disadvantaged now because maybe their parents simply cannot afford to get them to and from the class. If indeed the whole of government approach, as we have been told from the beginning, if indeed that was a working system, then you would have had the Ministry of Social Development being able to cross-reference things like persons who applied for the salary relief grants, so you would be able to tell employment during the pandemic, the persons who applied for different types of assistance, where their children are within the school system, because all of that is part of the application process. The household is part of the application process. If they were cross-referencing the data, you would know the students who needed not just devices and whatnot, but if both parents are unemployed, you would know where you needed to target school transportation as well. Because unemployed does not send you to school. It's not possible to pay the $70 in taxi fares. In some instances, some parents coming to me, $150 in taxi fares because you're taking 1, 2, 3 taxis who have had no choice but to increase their cost based on gas prices, the state of the roadways. I mean, these are all very interconnected issues. And we are being told, like I said, whole of government approach, whole of government approach. Where is the government? The whole of the government is silent at the moment. The whole of the government is failing, and we are looking on at the direct results of these failures. Additionally, if indeed the whole of government approach was working, you would also be hearing about what would be the impact of student support services in the remedial classes. Let us not mix matters here. These students have had an extremely difficult time. Just like the adults, they've gone through the fear of the pandemic. They've gone through living through this system. They've had to grapple with online school, being back in school. They've had to grapple with all the same social issues adults were struggling with, and they are children. Now they're back in vacation school, in vacation remedial school. This after having not scored well in the exam, which takes a toll on a human being. Again, silence on whether or not you are implementing student support services and utilizing the system to again ensure proper development, because all of us, the end goal of this is that these children get a fighting chance, the best possible chance at success, the best possible access to opportunities to succeed, because that is what we should all want. It ought not to be a space for mama guy and telling us it is okay when it really isn't. Additionally, utilizing the social services system, you can again find out what may be preventing the students from attending. Because I mean, I've heard the chatter, I've seen the chatter online about parental responsibility, etc., etc. Utilizing the whole of government approach from a policy perspective, you would be able, in some measure, probably not perfect, but in some measure, to pinpoint what is preventing the vast majority from attending. Right? It cannot be that we always throw our hands in the air. It cannot be that we say, listen, well, that's their children and their business, because as a society, we will pay a very high price for ignoring an extremely fixable problem. We will pay a very high price for ignoring a generation of people who absolutely need our help, who absolutely need our assistance. And so today, as I provide my assessment of what I've seen taking place over the last few weeks, I commend the teachers who are coming out. I commend the teachers and the parents who are also speaking out, because they are the ones who are telling us, giving us the information as to what is really happening in this space. And I want to say to the ministry, they would speak to you too if you would speak to them. And therefore, this is no secret. This is not unique information. This is not top secret information that you could not have had access to about what to put in place for remedial learning, integrating the system with psychological and mental health support. These things are not top secret, but you aren't talking to anybody. You are talking at us. You are consistently talking at the population and telling us you're going to do this and you're going to fix this. And then when it is not fixed, you find something else to blame. But the opposition's priority, the United National Congress's priority, is the children of this country. We are talking about the next generation of Trinidadians and Tobagonians, the future leaders of this country. We are not willing to put our hands in the air and say, oh well, too bad. We are saying this is a fixable problem. Implement targeted strategies. Do the sensible and do the right thing, because what you are doing right now is failing our nation. And so now I'll turn over to my colleague, MP Rambley.
Good morning to viewers and listeners. Good morning to all citizens of Trinidad and Tobago. Of course, this is our Sunday presser being brought on behalf of the opposition. I would particularly like to thank my sister MP, MP Anita Haynes, for that contribution. And I am here, of course, to talk this morning on the instruction of the Honorable Leader of the Opposition, Political Leader of the United National Congress, Mrs. Kamala Persad-Bissessar, Senior Counsel, to speak on an issue which came into the public domain and really has been marshaled by herself in a very meticulous manner in the public domain, all in the interest of the welfare of the people of Trinidad and Tobago. This issue that I'm speaking about is an issue which involves, and the public, they are very well aware of now, it is an issue involving the Attorney General, Mr. Reginald Amor, Senior Counsel. I can sum up what I want to say in an initial title: AG Amor is unfit for public office. And so I will go through some of, I'm not going to rehash details that we would have shared with you in previous Sunday pressers and other forums. But there are certain matters and a lot of unanswered questions. So I will get down into it. And I want to set it with a little context, because on the 15th of July 2022, the Law Association of Trinidad and Tobago convened a special general meeting, and they voted on a no confidence motion against AG Amor over his role in the ongoing United States civil asset recovery case related to fraud allegations in the construction of the Piarco International Airport. What was also debated at the SGM of the Law Association is a motion as to whether a call should be made for AG Amor Senior Counsel to resign as the Attorney General. Now, ladies and gentlemen, this morning I want to tell you why, regardless of the outcome of this vote, we cannot afford to leave a matter of such national importance to dissipate like a 7-day wonder. To do otherwise is to run the risk of plunging Trinidad and Tobago into further legal disgrace and sending a message to everyone that this is a jokey country and we operate by VAPs. Ladies and gentlemen, this just cannot do. Now, Attorney General Amos, Senior Counsel, admitted in the special general meeting that he misstated the full extent of his representation of his previous clients, Brian Quaitong and others. And in this regard, he apologized to his colleagues in the legal profession. It was against that backdrop, in that privately convened special general meeting, both motions were not carried. I myself, I am eagerly awaiting the official transcript or record of the special general meeting from the Council of the Law Association. It is important that the public sees the statement of the Attorney General containing the apology he made to members of the legal profession. Additionally, contributions made by the various speakers should be digested, discussed, and commented upon by members of the public. I take this opportunity, however, to say that I am particularly curious about the advent of a new offspring of jurisprudence. Based on the compelling statements of many senior members of the bar, the Attorney General, who misrepresented and or misstated facts and or failed in fulfilling the duty of candor required before a court and or acted with a lesser degree of duty of care required of his office, was able to rely inter alia, among other things, upon the following considerations in mounting a successful defense before his peers. And these considerations, namely, they are his age and lapse of memory, the geographical location or the physical space confinement at the time his evidence was given, testimonials from colleagues that essentially he was a good boy, extensive references to scriptural readings such as "to err is human, and he who is without sin cast the first stone." Other considerations were the intentional downplaying of the serious infraction by referencing the oft-cited local parlance phrases such as "it could happen to anybody" or "is not really a big thing now." That was one of the considerations. There are bigger problems to deal with in comparison with the infraction under review. That was another consideration. Another one, the degree of accountability expected of public officers in Trinidad and Tobago ought not to be equated to that of first world countries. Then, the fact that the process of review is not politically motivated is immaterial. What really matters is whether the decision at the end of the process will have a particular political consequence was of more importance with those considerations. Ladies and gentlemen, members of the media, I assure you that I am not being facetious, and I urge you to obtain a copy of the transcript of this special general meeting. On a serious moral and legal note, if these considerations can avail the Attorney General, who is the most central person to the administration of justice, the person who is expected to lead the legal profession, and by extension the society by example, they ought also to avail ordinary persons and litigants in the courts, before tribunals or disciplinary hearings, etc. Persons who may have failed to make full and frank disclosure before the courts or misrepresented and or misstated obvious facts in their affidavits and witness statements ought to be able to avail themselves of what has now emerged as a new defense that we heard from some very senior members of the profession in what can be considered a very compelling SGM. But moving along, I am here this morning to tell you that the recent SGM of the Law Association is not the end of the matter. And in case you were closing the fridge and think that you may have missed it, AG Amos Senior Counsel has not properly accounted for his actions or even remotely expressed any remorse to you, the members of the public. There are simply too many unanswered questions. It is impossible to reconcile AG Amos' dishonorable actions with the conscientiousness which is demanded of such high office as that of the Attorney General. So we in the opposition want to make it abundantly clear that AG Armour's belated apology cannot be viewed or accepted as the end of this matter. High standards of conduct driven by public demand can only be achieved by the removal of Mr. Armour Senior Counsel as Attorney General. Nothing less will do. I want to go to a quote, and this is a quote. These are the words of the UK MP Sajid Javid to UK Prime Minister Boris Johnson. And he says, "The tone you set as a leader, the values you represent, reflect on your colleagues, your party, and ultimately the country." So those are the words of Sajid Javid for those who are following the politics internationally. Ladies and gentlemen, our country continues to operate under very dark clouds of suspicion, possible recklessness, incompetence, and secrecy insofar as it relates to AG Armour's involvement in the Miami proceedings brought by the state of Trinidad and Tobago against defendants in Miami. You will recall that this case was brought on behalf of the citizenry against alleged wrongdoers and is being pursued in order to recover the proceeds of criminal activities, including damages. It means that if successfully prosecuted, we, the citizens, can possibly recover monies which were siphoned from our coffers by unlawful means, by unlawful activities. The Miami court proceedings has been managed by at least 8 attorney generals appointed by different governments, by both administrations on either side of the political divide over the last 18 years. It is one of the largest expense borne by taxpayers to get justice for us. The entire constitutional imbroglio which AG Armour placed Trinidad and Tobago in first came to the attention of the public on the 5th of June 2022 by way of an Express newspaper exclusive expose. You will recall that it was only upon the Express newspaper asking AG Armour about the matter that he responded and confirmed the Miami's court order disqualifying him and that the matter had been appealed. AG Armour stated then that he had not said anything on the matter before because of his disqualification, and due to the appeal, the matter was now sub judice. Well, he has been convenient with that position since then till now. So in other words, if it had not been for the diligence of the media, AG Armour would not have accounted to the public in any satisfactory manner, and the citizens whose taxes continue to fund this litigation would be kept in the dark. I want to deal with the sub judice no comment, at this point in time. Now, AG Armour, to our knowledge, is not a defendant in criminal proceedings before the court. He has not even indicated whether or not he stands to be cross-examined on account of the affidavit he has put in the proceedings. We have heard nothing about that. The Republic of Trinidad and Tobago is not a defendant in criminal proceedings before the court. Neither the media nor members of the opposition have commented on the merits of the criminal proceedings existing before the Miami courts. To date, no one has commented on the evidence being presented or to be presented before the Miami courts in the substantive proceedings. So what we have been discussing here in Trinidad and Tobago in relation to AG Armour's disqualification is not going to affect or influence a judge or jury in Miami. The appeal against the disqualification order stands to be determined as a matter of law. So I want to say that having regard to all the facts and circumstances, both on the court record and in the public domain, there is no basis in law for AG Armour's self-inflicted vow of convenient silence. In any event, there is no reason why Minister Faris Al-Rawi could not have accounted for the procedural steps being taken before the court. Such maneuvers, ladies and gentlemen, in this regard, continue to seriously undermine the accountability of government, the rule of law, and the administration of justice. Now, I want to talk a little bit about the legality of the filed appeal, because according to AG Armour's second statement of 20th June 2022, prior to the determination of the defendant's motion to disqualify, he had already delegated the role of giving instructions to Minister Faris Al-Rawi. he, A.G. Armour, did not have the power to delegate his role in the proceedings. Only the Prime Minister could have done same. In any event, when the delegation of this function, which falls squarely under the office of the Attorney General, when did it occur and when was it gazetted? The Attorney General must explain whether Faris Al-Rawi had the legal authority to instruct that the appeal be filed. This is a very important question. If he, Al-Rawi, now did not have the authority, then the Attorney General must further satisfy the population of the likelihood and prospects that the appeal can be challenged for want of authority. So, ladies and gentlemen, these are serious questions which continue to linger. Now, I want to talk a little bit about now moving away from that legal aspect of want of authority to the practical effect of the pending appeal. And you will hear about the further delay in the substantive proceedings and mounting legal costs. Because due to, again, to A.G. Armour's actions, the government has now had to hire a new law firm, White & Case, an elite international law firm based in New York, to replace Sequoia Law, the former attorneys on record for the state of Trinidad and Tobago. Having already spent some, and I may be wrong on this figure, but I recall it as about $13.5 million on Sequoia Law in retaining their services and in dealing with the matter, we now have to spend additional monies on an unnecessary appeal. An appeal which must remember was precipitated solely on account of the actions of Reginald Armour, senior counsels. Even if we are successful on the appeal, it would only have served to save our ability to continue with the court proceedings, but would not have in any way advanced the substantive proceedings closer to a trial and subsequent final determination. In other words, this already 18 years old matter, which was on the cusp, which was about to be fixed for trial, will be no closer to a trial even if we were to succeed on the pending appeal. Furthermore, even with the retention of White & Case, the government has lost before the U.S. courts in its attempt to expedite the appeal. We have read about that in the media, and the A.G. Armour, nor Minister Faris Al-Rawi, nobody, nor Prime Minister Dr. Rowley, no one has come out to refute that report. What legal costs are required to be paid by Trinidad and Tobago to the defendants on account of having lost the applications? Ladies and gentlemen, time means money. Longer litigation means more expense to the taxpayers of Trinidad and Tobago. Now I want to talk about the continuing status of A.G. Armour in the proceedings itself, because A.G. Armour stands disqualified from representing Trinidad and Tobago. The U.S. judge automatically disqualified Armour and the law firm Sequoia Law on the grounds of a conflict of interest, as Armour is now essentially both chief prosecutor and a former defense attorney. This disqualification is still in effect, notwithstanding the appeal. So the disqualification of A.G. Armour, the Attorney General of Trinidad and Tobago, continues. It remains in effect. I want to talk about the office of the Attorney General very quickly. The Attorney General is a member of the government and has two separate constitutional roles. A governmental role, in which he acts as a member of government in the performance of his duties, and a role as the guardian of the public interest when he acts independently in a quasi-judicial capacity. The provisions of the Constitution of the Republic of Trinidad and Tobago require the Attorney General to be responsible for the administration of legal affairs within the country. Legal proceedings for and against the state must be taken in the name of the Attorney General in the case of civil proceedings, and in the name of the state in the case of criminal proceedings. So this is how important our Attorney General is in the constitutional remit. The oath of office of the Attorney General. Mr. Armour, senior counsel, and this cannot be diminished. MP Anita Haynes, myself, the Honorable Leader of the Opposition, parliamentary colleagues, the Honorable Prime Minister and his MPs on that side, on the government side, they all took an oath of office. And I would like to think, certainly on our side, we take our oaths of office very seriously. A.G. Armour, on taking office, solemnly affirmed that, and I want to quote, "I will bear true faith and allegiance to Trinidad and Tobago and will uphold the Constitution and the law, that I will conscientiously, impartially, and to the best of my ability discharge my duties as Attorney General and do right to all manner of people without fear or favor, affection or ill will." And I want to highlight, in that oath, conscientiously, impartially, to the best of my ability discharge my duties, do right to all manner of people. So that is the oath which A.G. Armour would have taken. Now I want to move to A.G. Armour's controversial affidavit in the Miami proceedings. In a sworn affidavit dated 24th of April 2022, A.G. Armour stated that he, Mr. Armour, represented defendant Brian Quaitong between January 2003 and January 2008. On March 16, 2022, he was appointed Attorney General to the Republic of Trinidad and Tobago. In that affidavit, he spells out that Sequel Law, the Republic of Trinidad and Tobago's counsel, the lawyers on record in this action, conferred with him, Mr. Armour, who was now representing the Republic of Trinidad and Tobago as Attorney General. He goes further. He, Mr. Armour, notified Sequel Law on their first conference call on the 30th of March 2022 that he had previously represented defendant Quaitong in the parallel criminal proceedings. Sequel Law continued to discuss, according to Mr. Armour, the case management issues and logistics with him, Mr. Armour, including the dropping of certain claims brought by the Republic of Trinidad and Tobago, designating representatives to attend mediation and trial in this case, and having him consider, meaning having A.G. Armour consider and execute a settlement agreement with another defendant in his capacity as Attorney General of Trinidad and Tobago. The Republic of Trinidad and Tobago filed its 5th amended witness list on April 11, 2022, which included Mr. Armour on the witness list as the Republic of Trinidad and Tobago's representative. Neither the Republic of Trinidad and Tobago nor he, Mr. Armour, ever asked Mr. Quaitong to consent to him, Mr. Armour, being involved in this case, and Mr. Quaitong never provided consent. The question, ladies and gentlemen, arises as to what was the provenance of Mr. Armour, based on the facts known, or which ought to have been known, for his taking any part or role whatsoever in the subject proceedings. He is required by oath to be impartial. This required him to ensure fairness to the defendants in the ongoing matter. Ladies and gentlemen, as a matter of law, where a defendant has demonstrated a substantial possibility of a conflict of interest, prejudice will be presumed. So in his affidavit, A.G. Armour knew from the inception that the question of conflict was present. He notified Sequel Law on their first conference call on 30th March 2022 that he had previously represented defendant Quaitong in the parallel criminal proceedings. This alone warranted, indeed demanded, that he be wholly disconnected from the matter. So what you will hear and what we have been hearing consequent on this discussion, and particularly taking that particular affidavit, that controversial affidavit, into context, we have been hearing charades. Mr. Armour, an experienced attorney at law and a senior counsel, at all material times stated that he acted as junior counsel in the matter and proffered that by diluting himself as such, it was okay for him to play a limited role in the matter. I don't want to get too much into that because that has been really fleshed out in the public, and I really don't think that the population is falling for that. I couldn't recall, and because Mr. Alan Alexander, senior counsel, was of a certain, status that, one could only imagine themselves as being junior and all that nonsense and no take and whatever. In his affidavit itself, there were conflicting matters in that on the one hand, he stated that he was walled off without condescending to particulars. And on the other hand, he continued to deal with case management, etc. This can only be described as a charade. Any lawyer, any attorney at law who is worth their salt will tell you that if you are presenting yourself and you are engaging, whether before the court or you are engaging in your office in dealing with case management directions or issues, it is not a rubber stamping exercise. You have to become intimately involved with the facts and circumstances of the case. You need to prepare yourself with a strategy which will be told to you and discussed with you by your lawyers, equal law in this case, and you have to apply your mind with your own common sense and knowledge of the facts that you know. This is where the question of the intimate facts and knowledge that you possessed, having represented your previous clients, would come into play, and conflict would be obscenely real. Amor claimed that his initial affidavit to the court was prepared while he was in Europe on vacation, and he did not have access to his office records to fully recall the extent of his involvement in the case over 14 years ago. You mean to tell me that in this pandemic period and almost post-pandemic, that A.G. Amor, because of the fact that he's in a hotel room and whatever may be his geographical situation there, I hardly know that there are places where you cannot access Wi-Fi. I hardly know that you cannot access, whether through your phone, through your iPad or some other device, you can access documents. You can call for files. You can drop box voluminous documents and get into it. In fact, I have heard A.G. Arawi say that in the parliament, that, the government give you an iPad. The government give all your iPad. Why all you use it to read the laws? So why A.G. Arawi, your colleague who took over from you, didn't use his parliamentary iPad? You mean all you hold back the iPad from the man? Listen, this is another charade. So Amor claims that his initial affidavit to the court was prepared in this hotel room. And I don't want to go any further because I am awaiting the transcript from the official transcript from Law Association as to what some people spoke about, how the room could be and whatever. I leave that there. And he did not have access to his office records to fully recall the extent of his involvement in the case of some 14 years ago. That is really a pathetic charade. So this is just another charade, having already recalled that he had acted in parallel proceedings, was sufficient on any view to recuse himself from embarking on this matter in the first place. If he did not have full recall, then he should have refrained from swearing an affidavit until fully apprised. It is that simple. This did not, ladies and gentlemen, require a headless chicken approach. In conscientiously discharging his duties as Attorney General to do the best of his abilities, he ought to have known as a matter of law and the ethical requirements of the legal profession. This ethical requirements I'm now referring to is separate and apart from the Florida bar rules. This is even codified here locally, that he ought not to have engaged in any conflict of interest. Furthermore, if he was in doubt as to the extent of his previous representation of the defendants, he ought to have erred on the side of avoiding any potential conflict. I want to move on there. Enough of the charades that we see in that affidavit and whatever consequent statement Mr. Amor has put out. I want to deal with the Burke settlement. One of the biggest charades is A.G. Amor saying that his role was limited to handling case management issues, yet he was signing off a settlement agreement. The opposition has asked before, but I'm asking of A.G. Amor yet again, whether the document which he signed, which he claims was prepared by others, the Burke settlement, was that document in any way an indemnity for any of the defendants in the Miami proceedings? That is critical to know the extent of A.G. Amor's role in these proceedings. Did that Burke settlement entail dropping off certain claims brought by the state of Trinidad and Tobago against certain defendants in the Miami court? We know this government like to give indemnity left, right, and center. So we need immediate answers from AG Amor on this matter of what settlement did he effect in the Miami proceedings. I want to talk about due diligence required of Mr. Amor's senior counsel. Further due diligence would have required him to list all the matters he appeared in for and or against the state before he took up his post. And this is critical, you know, as a lawyer, if you're going to leave one office, which may be private practice, to take up office in maybe a state-run entity, maybe a corporate entity as the case may be, you have a duty to list your matters for several reasons, and one of them is a conflict. Former Attorney Generals would have done this, that before they took up the position, they either would have made clear there was no lingering vestigial attachment, if you want to call it that, to their law practice, and then going and operate. And I do know of a UNC Attorney General who clearly would have operated in a transparent manner and left behind a really thriving, lucrative practice, law practice, litigation practice, and totally absolved himself when he was Attorney General from having absolutely any interactions whatsoever with the cases which he formerly was invested in. So it was incumbent on him to do so if he desired to remain fully tethered to his oath of office. Further, his continuation to act in matters in which he previously acted would certainly have given rise to an assumption of bias. He knew, as per paragraph 2 of his affidavit, that he was responding to Brian Quaitong's motion to disqualify the plaintiff, counsel for plaintiff, and to strike pleadings. And he also knew he was responding to Steve Ferguson's motion to disqualify, and we call that motions to disqualify, as set forth therein. And I want to make it clear, and I do have the copy of the affidavit. I don't know if persons will see this, but it clearly says here that I do not intend in any disclosure in this affidavit in any way, and he goes on that he's preparing this affidavit. In other words, he's putting himself on oath and preparing this affidavit, and this is what he says: to defend both Quaitong's motion to disqualify and to strike pleadings. And that will become operative as we move on with the discussion, to strike pleadings. So this is the affidavit itself. Now, I want to say that he therefore knew that what was the grave importance of what was at hand. He certainly appreciated the circumstances and he appreciated the gravity of the situation, namely his disqualification as Attorney General representing Trinidad and Tobago, and an attempt by the defendants to have the entire case dismissed. When they say to strike the pleadings is what presents your case before the court. If your pleadings are struck, your claim is dismissed. You have nothing before the court. So he certainly knew that in addition to this risk of being disqualified and Trinidad and Tobago running the risk of being unrepresented in the proceedings, that there was a risk that these parties were trying to dismiss the entirety of the case before the court. The actions of Mr. Amor, senior counsel, in engaging in the clear conflict of interest and misstating or misrepresenting and failing to be candid before the courts with the facts before the court was in direct breach of his oath to uphold the Constitution and the law, to conscientiously, impartially, and to the best of his ability discharge his duties as Attorney General and do right to all manner of people without fear or favor, affection, or ill will. How, ladies and gentlemen, can this glaring dereliction of duty be accepted as being fit for him to be given a pass? We cannot, and certainly the opposition, and we know the majority of the population, they are not prepared to simply sweep this matter under the rug. Notwithstanding the contents of his affidavit of the 24th of April 2022, that he notified Sequor Law in a first conference call that he acted for Quaitong in parallel criminal proceedings from the same facts, he continued to involve himself in the matter and moreover to object to the application to disqualify him and the law firm. So knowing the importance of the matter, knowing that he already told him that, look, I represented these people before, he still continued to object to the application by putting the affidavit and going into the lengths of those charades that was codified. How are we, ladies and gentlemen, to reconcile this with the oath of office he took a little over a month earlier on the 16th of March 2022? He has not to date explained to the public or even to his peers in the legal profession or at all how, in his view, the contents of his affidavit and his conduct in the round to convince the Miami court that he should still act in the matter, limited or otherwise, accords with the oath of office he took. A.G. Amos Senior Counsel was duty bound to ensure that he did not act in the matter from the get-go. He failed to do so and resisted attempts to have him disqualified. Moreover, an appeal has been filed to maintain the same position. How is this now to be reconciled with his statement to the Law Association that he made an error but did not act dishonestly or set out to willfully deceive the U.S. court? How do you reconcile that? Now, I want to talk a little bit about Prime Minister Dr. Rowley's public aberration. One will recall that at a recent press conference, when asked by a member of the media as to whether he conducted any due diligence before appointing Reginald Amos Senior Counsel as AG, Prime Minister Dr. Rowley adopted an unduly uncivil recalcitrance against the reporter. Poor reporter, I was seeing here this morning, I was making a joke with the media earlier that he needs to save his energies for the press conference of the Prime Minister tomorrow. The Media Association, on a remark that of more serious note, the Media Association of Trinidad and Tobago voiced serious concerns over that particular scenario in light of the Prime Minister berating the media. The question as to whether Dr. Rowley conducted any due diligence must be asked of him again. And another critical question to Prime Minister Dr. Rowley is how does he reconcile A.G. Amos' dishonorable actions against the oath of office which he has taken? So this is something that Dr. Rowley, it is still falls squarely on him. I want to, as I try to wind up this, talk about the prejudice to both the defendants and Trinidad and Tobago. As I have stated earlier, where a defendant has demonstrated a substantial possibility of a conflict of interest, prejudice will be presumed. That is a matter of law. So in this case against Quaitong and others, they will of course have to pursue their rights as advised by their lawyers. I hold absolutely no brief for them. But you see, conflict works both ways. A.G. Amos' dishonorable actions and the resulting legal disgrace has adversely impacted on the confidence which citizens formerly reposed in the administration of justice. Our justice system has suffered irreparable damage, and the fact that the main perpetrator continues to occupy the office of the Attorney General is a travesty of justice. So I want to conclude, ladies and gentlemen, by asking and putting a few things out there. How is it that it became so easy for A.G. Amos to offer a belated apology to the Law Association? Remember, since 16th of March, and then he had his first teleconference with Sequoia on the 30th of March, he knew. So since then, there was a duty on him as a public office holder and high public office holder to start to account to the public by way of words and by way of actions. This was only put forward in the public when the media released the information, And the first time that apology came, it only came when he was put between a rock and a hard place in that private meeting called by the Law Association, that special general meeting, when he was forced to put his apology on record. Mind you, the apology was not, and this is what people have to remember, the apology was not offered to you, the citizens of Trinidad and Tobago, although you are the ones ultimately paying for the Miami proceedings and the unnecessary appeal which has now been filed. And people will say, well, what do I mean by that? Those are private proceedings, that is why we have to wait. So I want to ask, were members of the media invited to that meeting? Were they allowed to go into the meeting and to take notes and to take pictures as they're doing here this morning and to record? No. And therefore they have to await the transcript, the official record of the Council of the Law Association, which is put out to the membership, and possibly it will be put out for public consumption. And I'm calling for that today. So that appeal was not made to you, the members of the public. He has not done so. And in fact, in offering his thanks following that vote before the SGM, he responded to the Law Association and to members of the profession. But I'll come back to that. Clearly, there is a recognition by A.G. Armour that he has done wrong. Too many questions remain unanswered in this matter. And I want to just point to one headline. This headline is, I will go to the other papers as well, because I think all of the headlines are instructive between yesterday and today. But this morning, AG survives no confidence motion, but cloud remains, unanswered questions. So I want to say that that is something here that is in the Sunday Express, that too many questions remain unanswered in this matter. Whilst the legal profession may be contented with an apology, restoration of the public's trust and confidence in the rule of law and the administration of justice demands much more than an apology. We in the opposition, and I am saying outright, the majority of the right-thinking citizens of Trinidad and Tobago are of the view that nothing less than the removal of Reginald Armour Senior Counsel as Attorney General will suffice to restore public trust and confidence in the rule of law and the administration of justice. We in the opposition will not allow this matter to become a seven-day wonder. We will continue to call for the highest levels of accountability by demanding that A.G. Armour be removed as Attorney General. Thank you, ladies and gentlemen, and Ms. Haynes, I think that we may take the questions. Yes.
We have a few questions.
MP Ramali, I will begin with you first. Why was it so important for the Law Association to speak on this matter? We know that the association will have expressed that their views would not have caused the AG to resign or anything like that. But why do you think it was so important for the Law Association's voice to be heard on this issue?
Okay, so that is an excellent question, and I want to point to, of course, this is the Sunday Guardian. Even though the front page does not refer to the matter I'm talking about, it still does not paint the government in a good light because it shows the overall incompetence. But let's move away from that. When you go inside, you will see this article here, and it is headed, "We did all we could to hold the AG accountable." And this comes from a junior attorney at law, Mr. Kyle Taklal Singh. And what has happened is that, you see, the legal profession has a code of ethics. You tend to hear the senior members talk about we must engage ourselves in the practice of law and for the benefit of the litigants, as well as in benefiting the society as a whole. We lead with the highest traditions of the bar. And therefore, this is what I think the attorneys at law who piloted that motion, and I commend them for doing so. When they piloted that motion, it was really the only tool available to them as attorneys at law to hold the titular head of the bar to account. It is clear, as Attorney General, you cannot be hauled before the disciplinary committee. It is clear that he cannot be moved in other circumstances. There is just no device under the Legal Profession Act to do that. And the reason for that is because when you put that person there, that person is representing the head, the titular head. So this, I want to say that this role that A.G. Armour has to play demands much higher of him. Certainly the lawyers are of the view that they are not seeing those standards being set by him, and that does not paint a good picture for the practice within the profession, but it extends further. And I want to use the opportunity of your question to cite something, and I can share it with you after. When some years ago, there is something called the report of the 29th Council on the appointment of senior counsel, the Silk Report. And this is a document which is very instructive. What it says, and I want to go straight to page 4, it's a 14-page report, I think, but page 4. And this is what it says in discussing the role of senior counsels and the people who lead the bar.
Yes.
So I'm saying it in that context. And I quote at paragraph D. Their role as leaders of the inner bar and in the administration of justice must be one of standard setting of, among others, codes of conduct and propriety for the members of the legal profession, including, importantly, the law student and the junior member of the profession, in providing professional and academic benchmarks of excellence. So you could see what is contemplated of a person who is in the inner bar, a person who has achieved senior counsel, and in this case I'm saying that it is no different when you are the titular head. So I think in upholding the highest traditions of the bar, they were not seeing that coming from the Honorable Attorney General, and therefore they felt that this needed to be condemned. That motion is what is available to them to be able to hold the AG to account, and they succeeded in so doing, because they got the Attorney General to come down into the trenches, whereas all the time before sub judice, no comment, I want to be circumspect in what I say because there's this appeal, right? In the parliament we call him out and say you have no moral, no legal, no parliamentary authority, no authority whatsoever, but he still stand up there and pilot his motion and his bill. But in the profession, these lawyers knew that this would translate into something which would erode trust and confidence, it would erode the rule of law and the administration of justice. I want to go to something else now. This is page 5 of this report, and this is what it says. This is paragraph F, the late Mr. Carl Hudson Phillips, Order of the Republic, Queen's Counsel, captured this concept in his address to the Trinidad and Tobago Transparency Institute's annual general meeting in 2012, where he stated, and we all know who is Mr. Carl Hudson Phillips, Queen's Counsel in this profession. And I quote, the legal profession is one of the institutions on which the rule of law and the maintenance of our democratic way of life depends. Any sign of slippage should trigger alarm bells in the entire nation. The profession is too critical and important a body on which the public relies or should rely for the highest standards of conduct, and it goes on. And I think this is exactly, these lawyers are upholding what they have been taught, what has been left by the stature of men like Mr. Carl Hudson Phillips, Queen's Counsel, and I think that this is what prompted them to move that motion as they did. And it may not have been passed, but it certainly secured an apology from the Attorney General to them. It has not been made to the public, it has been made in that audience. I want to show something here that if it can be captured, that when this council promoted or passed this committee report, Mr. Reginald Amor has signed off this report as the president of the Law Association. So it's not Rambley and the UNC make up this document, though we would have contributed. So I hope that answers the question. But let me just put something in context for overall, if any other reporters have any questions and stuff. When one must understand that, you know, they are junior members of the bar. I'm not talking about how much years called, but they are considered junior members of the bar. The majority of those 40 members who came forward and signed that motion, and till now I am certainly curious as to how their names were published, exactly where and how their names were revealed and published in the public domain, that people started to attack them for political motives. And even in some instances, I saw one social commentator talking about their race. I would have never thought in 2022 that is the kind of, you know, discussion and attacks we will have. But be that as it may, one of the newspapers, and I think this is the only common denominator that all of the commentators, senior counsel and other commentators alike have in relation to that motion on Friday. And that common denominator is that it was not motivated by any malicious motive. It was not motivated by any political motive. That is the one common denominator. So I want to say that. So I personally would like to commend them and the manner of how they conducted themselves, and they wanted accountability. They got it. They may not be satisfied with it, but they got it. My personal impression of what took place is a David and Goliath situation. You had these junior lawyers come down there and they spoke. They were very erudite, they were very articulate, They were even emotive in how they presented their arguments, but they were definitely respectful for everyone as fellow members of the bar, from senior go right down to the juniors. So I want to commend them. Mr. Kyle Taklal Singh, I was there present. I did not participate in it because I did not want to give any room for a perception that it was motivated by politics. So I stayed out. You had Ms. Renuka Rambajan who spoke. There were other lawyers who I saw, the junior ones I'm speaking about now, who spoke on this. I know the Law Association. I hope they give me some latitude to say these things without the official transcript being revealed, because I see other persons talking about it. So I hope that they can give me some leeway, right? So it was a David and Goliath situation, and these lawyers really marshaled themselves. They got the Attorney General to come in, and albeit virtually, and give his view and to give his take on things. And at the end of the day, I don't know that he said anything different from what he has said in the public statements. The difference is, though, that he did offer an apology, and that spells volumes. That is a concession, and we must not forget that. It is a concession that he admits there was wrongdoing. Now, moving away from that, if it is that the legal profession in its collective wisdom, and I respect that, I want to make that clear, that they are satisfied with the apology, right? And they think that, it was not something that they wanted a motion of no confidence to be passed. That is fine for them. But you see, us out here in the public domain, who demands higher standards of high office holders across the board, we as members of the opposition, including me, I may be an attorney at law, but I also hold a specific duty to the constituents of Chaguanas West and to all citizens of this country. And we are not satisfied, as you have heard me this morning. Too many questions remain unanswered. I think I saw something in the news, which I think I pointed that out already. Oh yes, this is the article from, this is the Newsday I'm quoting here now. And what I want to go to is particularly page 15. And you will see this. I am a little bit troubled by this. AG humbled, grateful after no confidence motion defeated. He has not humbled himself before the population of Trinidad and Tobago, According to him, he has humbled himself before his peers, because some of his, more immediate inner bar peers came there and they had their things to say and what have you, and so he offered the apology. And in fact, I think some of them were sort of, hinting or referencing him that, look, this is the direction you should go. So I am not of the view that he was humbled in any way, and I will tell you why. This is not a personal attack on Mr. Amo. This is really in the public domain. It is public knowledge, and you, the members of the media, will recall that when we expected him to say something on a Wednesday, I believe it was a Wednesday press conference in the Parliament, or just outside the Parliament, he was very evasive and dismissive. In fact, he was arrogant about it, that I am here to answer my questions that, I think it had to deal with procurement, the procurement legislation and stuff, and the report, and he just said, no, I'm answering that. But the country and the media has a duty to the society as well, and asking the pertinent questions. What was the answer? He didn't even have the courtesy to say sub judice, say no comment. So I am here to answer this, and that is not before me now, and I have to rush back in Parliament. Really? This is the conduct we expect. So I have a little bit of concern when I see those type of headlines. It's not a personal attack on Mr. Amo. It is what the country is seeing and perceiving. And I also want to say, I think I spoke to the Guardian, but what I saw in the Guardian, we did all we could, and the lawyers really did all they could. That is what is available to them as a tool. So I think I have tried to answer what my view is without going into the details of what has been put forward in that AGM. I'm really trying to skirt that line until, in a respectful way, until they give the official transcript.
You see, with respect to, we heard you speak to the issue of remedial classes, etc.
Yes.
And you did mention that there has been concern around general parenting in Trinidad and Tobago as it relates to education. What is your take on that in terms of a parent's role in getting their children into the remedial classes?
Absolutely, there is a role for parents. That is not in question. It's not. But as policymakers, right? If the results are showing us, if the data collection is showing us that there is a failure, even if it's a failure in parenting, then there must be a role for the state to step in. That's why I said it cannot be that we throw our hands in the air. It may not be the Ministry of Education's role. That's why I was very clear to highlight that there is a space for social services in this instance. There is a space for us to connect policy making with whatever failures. There is a space for us to discuss things like, are there fixable issues with respect to the parenting? Is it that you simply can't afford? Is it that you can't? Is it a financial issue? Is it a disconnect? Is it that you could not cope with the pandemic and that affected your parenting? And then where there is a possibility for a policy fix, where there is a possibility for us to relook or re-engineer the state space in terms of intervening in family life where there is a demonstrated problem,
Yes.
there must be some policy solution. So I am not, and I want to make that abundantly clear, I am in no way diminishing the role of parents here. There's absolutely a space. Yes, the classes were created. There is a space for you to take the initiative and get your children there. But there's absolutely a space for policymakers where there is a demonstrated failure to step in. And if we are not doing that, we are creating a problem for the future. A problem for the future. And then you would see things like PM summons Jacobs worried about crime. Because these things have, a demonstrated impact on things like crime situation and income inequality, on unemployment. I mean, all the problems we're trying to fix now, these things will exacerbate. And so yes, there's a role for the parents, but we, as an opposition, we understand our role as policymakers. The executive is a policymaker. You are elected because you told the population you had policy fixes for societal ills. It's facts, right? You have said, we can do this, we can fix this. I believe the PNM's mantra was, let's do this. They're doing nothing, right? They're doing nothing. And so therefore there is a space for it. And so I would say, I would encourage parents to take, as best as they can, get your child to the vacation classes. But as a commentator on policy, I must insist that the Ministry of Social Development and Ministry of Education get to work and do what they can to bridge that gap.
Thank you.
One question for MP Rambley. MP Rambley, we haven't received the transcripts from the LAC meeting as yet, but one source in the meeting has indicated that one senior counsel used the defense of, quote, Mr. Amo is a good boy, unquote, as his main defense. How do you respond to that?
In the beginning of my presentation this morning, I did say that was a consideration, and I look forward to seeing how our jurisprudence is going to incorporate these highly persuasive or compelling factors, right, and considerations. I don't want to come across, certainly I am not intending to single out any member of the INABA, but I wanted to make this carte blanche statement. Having regard to what I personally saw at that SGM of the Law Association, and having regard to how I saw that these lawyers, how they conducted themselves, how they drafted their motion, how they articulated their position, and how respectful they were and persuasive, I am, on this matter involving AG Amo, not prepared to be led by any senior counsel. I will allow myself to be persuaded by these junior members of the bar. This is one issue that I am not. They say that you can't tell people which lawyer to go to. But me personally, if I had to go to a lawyer on this occasion, I'm not going to the senior counsels. I will go to these members, because what they have said, in my humble opinion, has a lot of relevance. It had the interests of the profession as paramount welfare, and it didn't, to answer your question now, it was not relegated to AG Amo was a good boy and that kind of arguments. So I don't want to go in depth. I really would like, this is what I was hinting at earlier. I think people should really get hold as quickly as possible of that transcript, that official record from the Council of the Law Association, because reading it alone will reveal a lot that I prefer not to say at this point in time. I think people will be fully informed when they read there. I don't want to come across as facetious. I leave that judgment call for the citizens of Trinidad and Tobago on what they hold of these members of the profession when they read what was said.
Also, you said you did not want to speak because you didn't want to give the appearance of being politically motivated. What are your thoughts that some of Mr. Amore's biggest defenders at the meeting included the chairman of WASA, the chairman of Angostura, the personal lawyer of the Prime Minister, and so on?
Okay, so that question sounds as though it is coming from a particular media house, because I read that in one of the printed press coverage yesterday. And what I can say is that it is correct that we had the chairman of certain state-controlled or state-owned entities coming and speaking in defense of A.G. Amor. I am not saying this to accuse anybody of anything, but when the transcript becomes available, I think Trinidad and Tobago is a very mature population. They are a sensible, right-thinking society. We generally like to be kept very much informed, and when we read that, I think that they will see for themselves the persons who spoke in defense of A.G. Amor. They will question, and they are entitled to question, whether they are all recipients of state briefs, and I expect they will ask questions under the Freedom of Information Act and otherwise as to exactly how many state briefs all of them have received over the last 7 or 8 years, as the case may be. They will also ask questions what boards they have been sitting in and what functions they have been performing. They are entitled to ask questions as to whether, yes, as you have, that whoever the media poses, they are right, and what they published yesterday, that you had the chairman of different state-run entities coming there to put forward arguments such as he was a good boy and that kind of thing. I mean absolutely no disrespect to any one of them. I am not attacking them, but in response to the question, I would urge the Law Association to give that report, to make it available at the earliest possible convenience, as in tomorrow, Monday, so that the people can look at those things and they will form their own views. I don't want it to be said that Dinesh Rambali came out because of a vote not having been passed by the SGM against a political opponent, that I am now coming to diminish the role of those young, brave, courageous attorneys at law who took that stance. I don't want to do that.
Regarding the settlement agreement that you spoke about, are you implying that this was somehow a clandestine agreement to absolve those in the Piarco 1 matter?
I think at the end of the day, when we are talking about the rule of law and we are talking about the administration of justice, this confidence that we talk about, and when we talk about erosion of the confidence, this is something that is intangible, but is an extremely real concept that pervades our society. Our democracy, the substratum of our democracy is that intangible trust and confidence that we hold in the administration of justice. So I am not implying clandestine acts, but when you have these things being done in these circumstances that we have detailed, where the Attorney General is saying on the one hand that I limited my rule, we didn't put him there, you know, the Prime Minister put him there. Right, he removed one sitting Attorney General and he removed that minister and put him in the next ministry and bring in A.G. Amor, Reginald Amor, Senior Counsel, and put him there. And from the word go, he was biased. I shouldn't say biased, he was conflicted, sorry. And being conflicted, he's embarked on a series of steps which he has admitted now that he fell into error, which when we have raised concerns, he agrees they are plainly legitimate concerns, all of them. He hasn't singled out anyone to say, well, Rambali talking something that I don't agree with. He has not done that to date. And so in that context, when we see that you are saying on the one hand, you limited your rule, according to you, to something being minimalistic, but on the other hand, you're signing a document which points to settling claims brought by Trinidad and Tobago with defendants over there in the proceedings, it is not good. It is too speculative. It is eroding the trust and confidence that people have in the administration of justice when these things are now coming to light against the backdrop of the series of missteps of A.G. Amor.
And you know, MP Rambali, just as we can ask if parents have to take responsibility for their actions or inaction. I mean, you can't on one hand as a ministry say parents have to be responsible and then not holding the Attorney General responsible for his own actions. So, you know, when you talk about things pervading society and leaders having to set example, on one hand, you are asking one of the senior most people in the governance of the Republic of Trinidad and Tobago to give them a blight and absolve them of responsibility for their own actions, but not want to seek to give that same blight to parents with respect to children. And so that's why we say the entire society will begin to crumble when we do things in this kind of haphazard manner.
And I just want to say MP Haynes has pointed to, you know, as leaders in the society. She will bear me out on this and will support it. The leader of the opposition, Mrs. Kamala Prasad Bisesa, always tell us that if you believe that you are doing the right thing, you must stand up for it.
Correct.
And I want to leave these words with the entire population, not just lawyers and that SGM. You are never wrong for doing the right thing. And in this matter, asking for accountability is the least you are entitled to. And the key stakeholders in this entire affair are you, the ordinary citizens. You citizens who continue to pay your taxes and somehow or the other you are sustaining the funding of this litigation. You all have the most critical stake in this entire proceedings. And therefore we in the opposition, we will not stop on this issue and we will continue to fight for greater accountability and higher standards of those who hold public office.
Since just one last question. Recently there was a survey published showing the massive discrepancies, the gaps in between ICT infrastructure facing different students.
Yeah.
Do you have a comment on that?
I do. Again, not a surprise. Trinidad and Tobago is caught in a space where we've known it. The rest of the world is going into the digital era, has been in the digital era and seeing advancement, and we remain very much in an analog space. I mean, the single most touted accomplishment of this government is the creation of a Ministry of Digitization, which, I mean, remarkably did not have a website as of October last year. And so, I mean, can you in any way call it a real accomplishment? So the ILO survey was not surprising. It remains a key element of the issues that we're raising, which is stop telling us that the problem is solved when it isn't solved, right? So you get the hardware in the hands of certain students, but there is no connectivity, there is no assessment of connectivity. The MiFi program, every time I raise a question, you get, the last I heard from Minister Imbut was that 1,400 were given out. Of that, I think 400 went to teachers, etc. I mean, it's ridiculous. It is ridiculous that as a society, we still have to be telling you that it is insufficient. You know it. You know, the government knows the problem, you know. And if I don't see it as my responsibility to come here and articulate a problem that we all know exists, it is why are they not enacting a solution? And I guess if you have to spend all this money on litigation and appeal and whatnot, you can't find the money. All resources are finite, and so if you are having to use it to fix your message, you cannot then go to a advancement of a society. So the ILO survey was not a surprise. The inequity continues to exist and become more and more exacerbated as the cost of living increase. As the cost of living continues to increase, have no doubt in your mind that this is going to get worse instead of getting better. The provision of devices is one thing. People cannot pay their electric bills, if people cannot pay internet bills, if you cannot think about things like that, if you can't pay to send your child to school, we are really heading for an ILO survey that will show us scarier circumstances next year. And this is not me down crying our nation. This is us explaining the realities of the situation, that if there aren't targeted interventions, if we do not move deliberately to a solution, we are going to get worse, and that is the path that we're on right now. Yes, so thank you very much, members of the media. Thank you very much to those of you who have tuned into our press conference. We will continue to raise these issues, and we will do so tomorrow at our virtual meeting, which would be shown on all UNT channels and on TV Jagriti, and so you can tune in tomorrow at 7 p.m. for more. Thank you very much.